The political atmosphere of Nigeria is becoming not just interesting but intriguing by reason of the activities of the actors, and I'm talking of the politicians, haven't managed in the past 2 decades or more to drag in the judiciary into their activities. So much so that we now talk about the judicialization of election processes. A bad news, if you ask me. But let's be clear, it is that following the defection of Governor Ugwummadu and his deputy, no less members of the State House of Assembly from PDP to APC, the PDP approached the court, insisting that it is not proper for Ugwummadu to have been elected on the platform of the PDP, so after being nominated and becoming a candidate, and now abandoning the same political party for yet another political party. That is, in their view, that was wrong. Please note that they approached the Federal High Court at Abuja, which is a court of first instance, and the court did not hesitate, did not find it difficult to uphold their contention. In consequence, the court, by Honorable Justice Eyang Ekwo, literally using the language of the common people on the street, literally sacked both the governor and his deputy and members of the State House of Assembly who equally defected. Now, that is a fact of what happened. With respect to the decision taken, it has polarized the entire legal profession. If you like, judiciary too, because we have seen conflicting judgments, diverse judgments on the same issue. Before now, there was, on the 28th of February 2022, a High Court judgment from that Ebonyi state that took the position that what happened was not an irregularity and could not have been the basis of denying the governor the governorship of Ebonyi State, ditto to his deputy governor as well as members of ditto to his deputy governor. So in less than a fortnight thereabout, you have this judgment hot, smoking on our laps. The issue is what happened. I think that largely what we have is a context between the law as it is and the law as it ought to be. It is an issue that has sufficiently polarized the marketplace of ideas. Now, being fought along the lines of legislation, jurisprudence, antecedents, study decisis, as well as the moral implications of what has happened. In other words, there's equally a clash a context of law and morality. In other words, whereas you could justify what has happened within the context of the law as it stands today, particularly relying on appellate court decisions. When I mention appellate court decisions, I am referencing in particular the cases of Attorney General of the Federation against Abubakar Atiku. That was in 2017. But more particularly, the case of CPC and Ugwummadu. Now, it used to be the law under the Malachy and INEC case that the votes cast in an election belong to the political party. This was how Malachy, by whiskers, not only escaped what happened and became the governor at that time. However, in 2010, as it is in the recent electoral amendments, the legislature has amended the Electoral Act in the same way that these other appellate court decisions have taken a different view, overruling, annulling the principles established in Malachy and Annex case. So what is the position of the law now? The position of the law as enunciated by the appellate court, including the Supreme Court, relying on Abubakar, Attorney General of the Federation, and Abubakar Atiku, more particularly CPC and Ugwummadu, is to the effect that political parties are mere vehicles with which the candidates who hold the trust, who holds the will of the people in trust, move and get to the destination of the government house in the case of governorship election. In other words, the political parties do nothing more than canvassing the votes on behalf of the candidate. It is reasoned, and rightly too in my view, that the argument cannot be otherwise, because it is not a political party that will be sworn in. I've not seen anywhere, whether within the Africa or anywhere where democracy is practiced, where political parties are sworn in. It is a candidate that ran on the platform of the political parties that are sworn in, given certificate of return. So in effect, they, as canvassed in those cases, or held in those cases, are the real owners of those votes, and they hold it in trust for the people. The local parties canvass for these votes, they mobilize funds, and sponsor this, and campaign for him. Ultimately, he is the one who is sworn in, and to whom certificate of return is given. So effectively, the principle laid down and as enunciated in Malachy and INEC the Falekes case, and even much earlier, the Hakim case, have all been eroded, paving the way for the present state of the law. So the argument that were predicated based on section 308, 221, 222, 68, 1G, and so on and so forth, were found not to be appropriate in the circumstances. It is on the basis of this that, if you like, this judgment was on the 8th of March. On the 9th, which was the next day, the lawyers, and I'm sure they didn't sleep throughout that day, successfully filed their notice of appeal. And by yesterday or today, they have brought yet another application, which is a motion on notice before the same lower court, which is permissible under the law, urging the court to stay execution of the judgment it has earlier given, pending the determination of the appeal that they have filed. So I'm sure I've been able to give you an overview, a historical account, the legal implications, and where the matter stands today. Let me respond to that. Section 308 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, is the exact provision of the Constitution that talks about immunity to certain political office holders. And there are 4 in category: the president, the vice president, the governor, and the deputy governor. They are immune from criminal and civil prosecution during the pendency or during the time they occupy those offices. However, they can be sued in their official capacity. In other words, you can sue the President of the Federal Republic of Nigeria and join the Attorney General. And we've done that so many times. You can sue the Governor of Kogi State, Lagos State, Akwa Ibom, anywhere. Join the Attorney General. In short, you see that the case I had earlier referred to is Attorney General of the Federation and the article. You could say Attorney General is not part of it. Attorney General acts on behalf of the government. So you can also sue those exempted in their as nominal parties. You can sue. So in 2 instances, there are exceptions. You can sue them in their official capacity. You can also sue them as nominal parties. In effect, what is sought to be checked by granting immunity to those occupying these executive offices is to avoid distraction. And mark you, the law has been developed to the point where they can be investigated. Investigation can be concluded on them. In other words, don't forget, investigation includes summoning, asking questions, and doing that. They can be investigated. What you cannot do is to prosecute them or sue them. So that has also been qualified, arising from a different case. And that's my response. I imagine that by precedents, you also include where do we ought to be? Where, I mean, it's a nation. It's about nation building. It is work in progress. Look, make no mistake about it. The hues and cries that has attended this judgment is not misplaced. A nation has come to the point where we must rise in unison and take a position, if you like, an informed position, arising from the challenges we have had as a nation, that will enable us advance the course of our progress in the direction of where we want to be. Yes, it is good to talk about law, the rule of law, and the state of the law. But no country makes concrete fundamental change by remaining where they are, by fastidiously remaining where it is. Changes are made when people think outside the box, take fundamental positions, and advance the course of their journey to an egalitarian society by shifting grounds and approaching the law the way it ought to be, rather than the way it is. In this regard, I do believe that there is a serious moral strength in the judgment that was given. Even if as the law stands today, it is not consistent, in my view, with decided authorities, this time appellate court decisions, as well as the Constitution and even the Electoral Act. What the people are saying and what ought to be considered is what the judge has reflected. To say, what is the moral capital? Where is the morality? Where is that conscious response? Where is the bond you had with the people? Where is that umbilical cord that connected you to the people through that election? How can you arbitrarily sever that umbilical cord? Running in that cord are the promises and manifestos and assurances and the social contract by which you convinced the people to give you the vote through the manifestations of the political party. To what extent can you now arbitrarily, unilaterally, whimsically abandon all of those promises, all of those manifestos, and jump into yet another political party that professes other ideologies and manifestos? We're not too bothered about the similarities in all of them. But in principle, to what extent can you do that? Now, in conclusion, the Constitution must also be tinkered with, because this confusion has arisen because there is no clarity as to what happens when a governor, when an executive officer decamps with respect to the legislature. That was adequately captured under section 68 1G of the same Constitution, which allows a legislature to cross carpet, move from one political party to another, provided he is able to prove and establish the fact there is a split or crisis in the party that sponsored him to that office. In the case of governor, there is no such constitutional provision. So the judge was in my view, and with due respect, creatively labored within the realm of his judicial powers and capabilities to further interpret the law and came to the conclusion that he came. But the beauty of the situation is that there is no other way by which our constitutional democracy is consolidated, particularly regarding the position of the law, by the nature of contest that we're witnessing at the moment. It is by far better that we're witnessing this hot air legal contestation and debates than that people have risen in arms and violence to contest the propriety or otherwise of what has happened. I had written in the past, very long time ago, at the inception of this dispensation, I'm talking of the Fourth Republic, in an article that I captured the camp as departure to lampoon the integrity quotient, I mean the very low morality with which people just toss carpet in the morning, afternoon, and evening, as if political parties have no meaning. Political parties are by far more than what we're experiencing in our clients. And until they are reined in one way or the other, we'll continue to have the kind of defections that has not brought value, that has not consolidated, that has not deepened the constitutional democracy that we're practicing. Thank you. By the express orders, consequential orders made after the judgment, by the consequential orders, you know, they were very clear and blunt. One, both the governor and the deputy governor ceases to be the governor of Ebonyi State. Both of them must refrain, must stop from parading themselves as one. The People's Democratic Party should nominate the names of their governor and deputy governor, forward the same to INEC. INEC is obligated to accept those names and declare them as winners of that election, and what? Issue them certificates of return. Salaries collected within the time when they purportedly won the election, and the time of the judge must be refunded by the persons affected, and so on and so forth. So the judge was clear and suffered no ambivalence in giving the orders. It doesn't stop there. Under section 241 of the Constitution, those who are affected, in short, also under section 25 of the Court of Appeal Act, those who are affected by that judgment are at liberty to file an appeal. And they have exercised that right, duly given to them, and filed the appeal. Having filed the appeal, there is yet another power that they have within the ambits of the law, which is in conformity with the rule of law, to now approach the same court that gave the judgment, seeking for another staying execution. In other words, stay the implementation or the execution of these orders and judgments you have given, pending when the Court of Appeal will determine this matter. What does that mean? It suspends it puts into abeyance the orders that are made. And I hope you have seen even the certified to copy of the order, the interim order, which will take some few days, 7 days. It's also renewable, within which the other party will come and see if they can set it aside or accept it and go and face the appeal. So as it is now, as it stands, Governor Mahi and his deputy, Kelechi, are still the substantive governors and the deputy governors of Ebonyi State. And it is likely not going to change until the Court of Appeal, and by, to be frank, the Supreme Court, because I see it going upstairs, whichever way the Court of Appeal decides. That's the position.